A cornerstone of the workers' compensation system here in Pennsylvania is that workers' compensation is the exclusive remedy for injuries that happen on the job. What that means is, for an employee who is injured in the course and scope of their employment, they are limited only to the benefits that are listed in the Workers' Compensation Act. Usually, that will be wage loss, medical benefits, and specific loss benefits. There are also additional benefits in the event of a fatal claim. This exclusivity and immunity is contained in Sections 303 and 305 of the Pennsylvania Workers' Compensation Act, and essentially states that employers and insurers are immune from tort liability for injuries that happen in the course and scope of employment. This immunity also extends to a co-employee who may have caused the injured worker's injury. However, there are some exceptions to this blanket immunity and exclusivity of the workers' compensation system. If your employer is uninsured, you can sue your employer in the Court of Common Pleas and recover damages like pain and suffering. You aren't limited to the Workers' Compensation Act. This also applies in cases where personal animus is the reason you were ultimately injured. Sometimes this exception can also be extended to intentional infliction of emotional distress claims. There are other types of claims that are not even covered by the Pennsylvania Workers' Compensation Act, such as wrongful termination claims or discrimination claims. A significant area of litigation in the exclusive remedy arena is in staffing companies. Staffing companies typically will hire someone, pay their wages, and insure them for workers' compensation, and then place them at different placements where the worker will actually be performing the job. When the worker is injured, typically the staffing company is the one who's paying workers' compensation benefits, but not always. What can come up in negligence actions is who is the employer for purposes of that workers' compensation immunity. If the place that the injured worker was working, not the staffing company, claims in the workers' compensation case that they are not the appropriate employer and they are successful in that argument, they can be precluded in a negligence action from claiming that they are now the employer. If you have questions about what benefits you may be entitled to, or what other actions you may have as a result of your work injury, click the link in the description below for a free and confidential case evaluation.